everyone for taking time out of your busy schedule to join us today. We're so thrilled to be able to bring this presentation and this topic to you. My name is Rana Simmons. I am the Director of Policy for the Colorado Coalition Against Sexual Assault, and we worked really hard this legislative session to pass House Bill 1035, which creates new housing protections for sexual assault, stalking, and survivors of domestic violence. And I'm joined by my two colleagues.
Hi, I'm Sarah Reimer Summers. I'm the statewide Civil Legal Services Coordinator at Rocky Mountain Victim Law Center. RMVLC is a nonprofit law firm working with three programs: the Victim Rights Act program, upholding victims' rights throughout the criminal justice process. And then we also have two programs working with access to civil legal information through our LINK program, the Legal Information Network of Colorado, and also a program based out of the Colorado Division of Criminal Justice, special project there working to increase access to civil legal services for crime victims across the state.
Hi everyone, I'm Stevie Gray. I'm the Housing Program Manager at the Colorado Coalition Against Domestic Violence. I'm just excited to be here with you all today to talk a little bit about housing protections. So if we can go to the next slide. Just to give you an idea of what we're going to be talking about today here together, we're going to talk a little bit about the federal housing protections that are available for survivors, and then Rana is going to talk to us a little bit more about the state bill that CCASA passed this last session, House Bill 17-1035. And then Sarah's going to lead us in some more discussion around the implementation, including some case studies and sample statements. So that's what it's going to look like here with us for the next hour. So we want to hear from you a little bit about some of the potential housing issues or barriers that you see when working with survivors. So if you want to just type some of those up into the chat box, we'll give you a couple of minutes, and we would just love to see some of the things that maybe that are coming up often for you and your work that you do.
And while those start rolling in, I guess what we can share is that that housing protections is something that we heard from our membership for years, that is necessary, is needed, and is often a barrier to safety for survivors. I know that when I first started working at CCASA, the housing protections policy was the #1 priority, and it was handed down to me really from Karen Moldovan, who formerly held the position as policy director at CCASA. We had an intern do extensive research on housing protections throughout the country, state-by-state comparison, and this was certainly the largest priority of our membership.
So we have two people mentioning something along the lines of being evicted when they report crimes like DVSA, so domestic violence, sexual assault, to the police.
Yeah, that's a big one. And we're definitely going to be hopefully being able to address some of the issues and kind of give you ideas of how to continue to support and help survivors access these protections. Is there any more? And we can give you time to throughout as we keep talking. We just maybe encourage you to hold these questions in your mind, and definitely encourage you to ask questions throughout, and we'll try to address those as we move through the presentation. All right, so we're going to talk about the Violence Against Women Act, which I'm sure most folks, if not all on the webinar today, know quite a bit about, but we thought it was important to just also give the framework of what's going on the federal level and what protections are available there, many of which have come about in the last reauthorization of VAWA in 2013 and are sort of slowly being implemented. So just to give you a little background in terms of when we talk about these protections through VAWA, we're specifically talking about federally funded programs, primarily through Housing and Urban Development, or HUD. So that's what programs this would cover. And if you want an exhaustive list of what's covered, just let me know. But really thinking about, housing choice vouchers or Section 8 as it's more well known, or public housing authorities, programs, things that are HUD funded, have to follow these protections. And so through VAWA, a landlord cannot terminate a lease, refuse to lease to someone, or evict someone just because they are a survivor. And this would include survivors of domestic violence, sexual assault, or stalking. So this kind of is the spectrum of ways that survivors are protected in terms of leases. They are able to evict someone if they're not paying their rent, or if they violate other terms of their lease. So that can also be is something that landlords are able to do. More recently, through VAWA, they did extend sexual assault to incorporate state and tribal laws. So there was some more clarification around that term, that sexual assault is any non-consensual sexual act as prescribed by federal, tribal, or state law, including when victims lack capacity to consent. So that sort of broadens that definition of sexual assault. So this can kind of help apply to more survivors. And some of the further protections through the 2013 reauthorization, we talked about how landlords cannot evict someone, right? But survivors are also able to terminate their lease under these federal programs. So they can terminate their lease if they feel like they're in danger from staying where they're at due to the violence that they've experienced. And so this is going to be somewhat similar to what our state law looks like, which Ron is going to talk more about. But within that termination of a lease, a survivor would have to write a letter to that landlord and also show some sort of, quote unquote, verification. So that could come in the form of a police report, a court order, but also what they really tried to do with this latest reauthorization is to try to create a lower barrier of certification, as you can see on the last bullet. So some HUD-funded programs may have just a form that they ask tenants to fill out if they want to get out of their lease, that just they self-certify. But under VAWA, they can also have a letter from an advocate or another professional that's worked with them that can verify the abuse. So there's many options. And I'm happy to give you a larger sort of list. I also have some brochures that I could send that sort of go into some of that, those steps. But we'll also talk more about what that looks like here in Colorado under state law, which I think will help in this as well. The other thing too is the lease bifurcation is also a protection available, which means that if a survivor is living with an abuser in the same unit and they would like to, either they would like to get off the lease or they want the abuser to get off that lease, that there is an option for them to stay in that unit and for the landlord to take the abusive person off the lease. And so the other nice thing about this is actually if, say that you have a survivor living with an abuser and the abuser is the one that is under that voucher or under that housing authority, and the survivor is not hasn't qualified, this also gives them a chance to have some time to try to but try to qualify for the housing assistance. So that they can't just kick them out just because there was abuse happening against them, even if they're not the ones on that voucher. Under VAWA, they need to be given some time to try to see if they qualify to stay. And so this is also kind of helpful under that circumstance. It's a little unclear in terms of how much time they have to give them, but they do have to give them some amount of time to try to qualify. Some of the kind of more vague, we don't quite know how this is going to look, is under that third bullet talking about protections against the adverse effects of abuse. And so what this is sort of looking like under HUD guidance is talking about things like, survivors may have bad credit history, abusers may run out their credit or, continue to get them evicted, which can look bad, right, when survivors are trying to get into housing. And so under VAWA, there's sort of this guidance around that landlords need to take into account these types of things that may come up that survivors may have on their record when trying to get into housing. And again, we're specifically talking about federally funded housing. And so this is fairly new in terms of HUD now trying to apply this to current housing programs. So we're going to kind of see how this plays out. But really what they're trying to do is to say, you really need to take into account how abuse impacts potential tenants, including that low barrier certification, including the fact that survivors may have these different, quote unquote negative things on their background due to the abuse that they've suffered. And this is where I think advocacy is really vital as well, is that we as advocates also have an opportunity to do some education with landlords, even though they're, supposed to follow these different guidelines and laws, that sometimes those, helping them understand how credit might be related to victimization or property damage or even a survivor's own criminal record. And so these things are still playing out, and we're going to see how that looks, but it's exciting that we're starting to see more, I think from the federal level, more guidance around how those programs can better serve and protect survivors of gender-based violence. And I also want to say that I forgot to say in the last slide that through VAWA, these programs also have to provide new tenants. Every new tenant has to be given a sheet or some sort of information that tells them about their rights under VAWA. So every tenant, when they move in or they're trying to apply, should receive information on their rights. So, all right, next slide. All right, so the other thing that's fairly new, so this came out in the last reauthorization, but is just now starting to be implemented in HUD programs, is this idea of emergency transfer. And so under this guidance, these programs, public housing authorities must adopt a transfer policy to allow survivors to transfer to another program that's still covered under that public housing authority if they feel like they're in danger. And so this sort of helps them to not lose that low-income housing or that voucher. So these programs have to be able to say, to give someone the opportunity to move into another property that they manage under that public housing authority, or even another public housing authority, to work with across systems as well, to try to keep this person in their low-income housing, but be in a safer place. And with survivors of sexual assault, they can request this transfer if the assault occurred there during a 90-day period preceding the transfer. So there's some different things that are going on. That this is, again, still very new, and they had pretty much to the end of this year that they have to be compliant with this. So we're following it, but just good to be aware that this is something that survivors should have access to, and kind of going back to that low barrier piece, that the quote unquote proving the victimization should not be a barrier in order to apply these protections. So I know that's kind of a lot of information, but again, I'm happy to provide more sort of handouts and things that you can go back to and reference, and I'm also available as an ongoing resource. But moving forward, I'm going to pass it over to Rana to talk to us a little bit more about our state protections.
Thank you, Stevie. So like what was just shared, we're going to shift focus a little bit from our federal guidelines to what is now implemented in Colorado. And just to give a little historical context, I know when we were answering those questions before, I talked about how this was a policy priority that was kind of handed to me when I first moved here and became a CCASA staff member. And this was something that our policy committee had been working on for a long time. We had a white paper, there was stakeholder work that was already in process. And so this data right here is just kind of a snapshot of a national survey that basically gave numbers to the anecdotal evidence and the stories that our advocates had been hearing for years, with the idea that safe housing, or that housing was a barrier to safety for survivors. So just to go over this really quickly, it's says that 88% reported sexual assault victims often need to relocate quickly. 58% reported instances of landlord against tenant sexual assault, again, creating that need to relocate. 79% of those cases, victims reported that landlords refused to repair locks, supply heat, water, make living space safe, and made sexual propositions to tenants, stalked tenants, and engaged in unwanted sexual contact with tenants. So not only did we have survivor stories, advocate stories, national data, this was just a key priority for us to push forward in our legislative advocacy work. So in the 2017 legislative session, we worked with Representative Dominique Jackson and Senator Cook to create House Bill 1035. And if there's anything that I want to kind of leave you with, an explanation of this bill is that it did two things. It expanded protections and it elevated possibilities for victim verification. So expand and elevate. Those are the two words that I want to leave you with to define this policy. So essentially what 1035 did was it expanded protections to include sexual assault and stalking survivors. Before this bill passed, the only type of survivor who was afforded housing protections in the form of the ability to relocate were domestic violence survivors. And so this bill expanded that to not only continue to provide protections for domestic violence survivors, but also to include sexual assault and stalking. The second element of the bill was that it created new pathways to safety for survivors. And what I mean by that was, when we talk about victim verification, before 1035, there were only two options for victim verification. The first being a law enforcement report. So you had to be a survivor who had reported the crime to law enforcement. Law enforcement had generated a police report. You could then take that police report, show it to your landlord, and legally break your lease. Or your second avenue of victim verification was to provide a personal protection order showing that you had in fact engaged the system, you had been given a protection order, and then you would take that documentation to your landlord and you would be able to break your lease. So those are good, and that is still current practice even after this bill. But that is not covering survivors who do not engage the criminal legal system for whatever reason that is. We know as advocates, right, that not every survivor who walks into our office is someone who feels comfortable, ready, willing to engage the criminal legal system, but still needs access to safety, especially in housing. And so what this bill did was create two new pathways for victim verification, one being in the form of an application assistant designated through the Address Confidentiality Program. If folks have any question about what an application assistant is, please feel free to write it in the chat box or in the questions box. And essentially, that is the person who helps with oh my gosh, I'm forgetting the word. Stevie, help me out.
Address confidentiality program?
Yes, I'm sorry. The Address Confidentiality Program, where you are able to have a confidential address and have your mail sent through ACP. And so they're the folks who designate that or are certified for that specific program. I'm sorry, I'm losing my words right now, everyone. And so that application assistant is now tasked with another ability to verify victimization for the purpose of breaking leases. The second alternative pathway that we created was to authorize licensed medical professionals to also be one of those verification mechanisms. And so now what you have is this ability for a survivor who wants to access criminal legal, who wants to access an application assistant, which can be found at a community-based advocacy center, or a survivor who is accessing the healthcare system, perhaps someone who got a SANE exam done. And all of those different types of survivors have the same access to housing protections where that didn't exist before this bill. Also, this slide, I think, answers the question that was posed at the very beginning of our webinar, this idea of survivors being evicted when they report to law enforcement. So House Bill 1035 prevents that from happening. Well, I don't know that it prevents it, but it makes it illegal. And so what we saw here, and even in testimony, when we had advocates and survivors come and testify in support of this bill, we actually had an individual bring an eviction notice where on the actual notice it said that this family was being evicted because of domestic violence. And it was pretty powerful to see the reaction from the committee, because one, that shouldn't have happened, that's illegal, but to see our elected officials kind of react to that piece of evidence. And I think it really helped them champion this bill and champion support for this bill, because no survivor should be evicted as a result of victimization. So this bill, again, expands those protections, not just to domestic violence victims, but also to sexual assault and stalking victims. So this bill went into effect on June 1st. And again, it's authorizing 2 new pathways to safety through the application assistant and a medical professional. And here's some information about how to write a statement verifying victimization. So these bullet points here are just a couple of things you want to keep in mind when you're writing that statement. And we're going to get into that a little bit later with Sarah, where we've created some templates for you to use. But essentially, what that statement needs to contain is the type of victim that a survivor is. So is it a victim of unlawful sexual behavior, stalking, domestic violence, or domestic abuse? There needs to be some mention of imminent danger, that this person is in fear that victimization will happen again if they do not relocate, and then also referencing the statute, which is CRS 3812-402. This gives a little bit more context about which professional is able to write a statement for the various types of survivors. So we were not able to include licensed medical professionals as a group that can verify stalking. We got a lot of pushback from the apartment association and various opponents of the bill. And essentially, it may not make sense, right? If someone is being stalked, they may not encounter a licensed medical professional because they may not be experiencing a form of physical abuse that would result in medical treatment. So for the law enforcement report, protection order, and application assistant, those 3 professionals are able to verify all types of victimization, but a licensed medical professional is only able to verify domestic violence and sexual assault, not stalking. So that this gives a little bit of clarity around that. And this is just more context about writing a statement. So it talks about agency letterhead, if you're an application assistant, to include your registration number, reference the statute, a statement talking about what type of survivor you are working with, who needs this service, and then of course your signature at the bottom. And I'm going to turn it over to Sarah now to explain the templates that we created that hopefully will benefit you when you are working with survivors.
So this,
Sorry to interrupt, but we just had a question come through.
Sure.
The question is, as a DV advocate, am I an application assistant or other is qualified to verify DV? I'm reading it verbatim there.
So an application assistant is someone who is designated through the address confidentiality program. Many community-based advocates are designated through that program, but essentially you would have to complete a training facilitated by the address confidentiality program. And perhaps after this, we can send out some information for who to contact if you have not received that training and if you are interested in receiving that designation so that you can provide this service within your center. Is that helpful? Does that answer?
Okay, so this first, just moving on to the first sample written statement here. And this first sample is for licensed medical professionals. And this is, as Rana mentioned, this is again a part of that elevating the platform for victim verification mechanisms. And so in this first statement for the letter for the licensed medical professionals, it should be on the letterhead of the hospital or doctor's office. And it does also need to be signed. Going through, it does need to mention the type of victim. Again, it needs to mention the statute, CRS 3812-402. And it does need to state very clearly that you have actually examined or consulted with the victim and that you're able to verify their victimization. Can we move to the next slide here. And this next one is the sample written statement number 2, and this is for the individuals who have actually been through that training that Rana mentioned and who are the application assistants. We got this information from the address confidentiality program stating exactly what would need to be required in this written notice. It would obviously need to include the name of the application assistant as well as their registration number that they're assigned through this through the training that they complete. You can see here again that it does need to mention the statement, the statute specifically, and needs to name the survivor and also name the type of victimization, and then of course be signed and dated there. So we're going to go through some case studies, and these are based off of cases that RMVLC has come, but have been changed a little bit for the purpose of this training. And so I'll go ahead and read it. You can read along also on your screen. And then we have found, when we were developing these, we counted 7 kind of major issues. And so would be interested to see as you're reading how many issues you see. And so you can type those in, see if you can type in some of those issues that you see and maybe some information on how your organization would handle a case like this. A month ago, Leora, a 21-year-old woman living in an apartment, was at a party at her neighbor Jason's house. Jason, who's 24 years old, was intoxicated and began making sexually explicit comments about Leora. Leora asked Jason to stop, but he continued with the unwelcome advances and forced Leora to have sex with him. Leora went to the hospital directly after the sexual assault and completed a SANE exam, but chose not to report the crime to law enforcement. She does not wish to report the crime at all due to threats that Jason has made. Jason still lives 4 doors down from Leora. She's afraid to leave her apartment and go to work because of the fears of another sexual assault. Leora wants to move to the other side of town and move on with her life, but her landlord told her that she cannot get out of her lease early without presentation of a police report. Leora's landlord told her that if she wants to get out of her lease early, she'll have to pay off the remainder of her lease. What can you tell Leora? And so in this example, it also illustrates that a lot of people are not interested in reporting to law enforcement, either due to distrust of the legal system or a variety of other reasons. And so create this new law is really helpful in that way, and that it does create these alternative pathways for someone who will go to the hospital to receive medical attention, but is not interested in calling the police and reporting the incident.
So what I think is really great about this example is that, I mean, this feels like something that a community-based advocate would encounter often, is that someone who is seeking options, who's not interested in reporting to law enforcement at this time, who is in imminent fear or danger, and is really just wanting to find housing find safety in housing, to then be able to kind of like move on and explore perhaps other options.
Mm-hmm. And so in looking at this example in terms of the next steps or what you can tell Leora, you know, I would say that it's always important to reassure the survivor that it's okay, you know, that they do have options to report or to not report, and just, you know, validate and reassure them that they do have the choice there and that it's not kind of a one path only. Also, as an advocate, of course, you cannot advise someone if they should or should not break their lease, as that would be going into the unauthorized practice of law. But being able to provide information that the ability to break the lease under this new HB 17-1035 does exist. And then also being able to just provide the support as they go through this process. And based on this exam, since Leora did go to the hospital, a sane nurse would be able to provide that written notice there.
Shall I move on?
Sure. So in case study number 2, I'll read it also, and you can read along on your computers there too. You get a call from Tony, who's an undocumented student. His partner was arrested about 3 months ago and is currently in jail for domestic violence and abuse. Tony mailed his landlord a copy of the police report and noticed that he needed to vacate the lease before his partner was released from jail. 1 month later, Tony has not heard back from his landlord and is still living in the apartment. He asks you why he was not allowed out of the lease and what to do next. So how can you help Tony? In this case, this is really illustrating that as well as providing the written notice from Tony to state that he does wish to get out of his lease, and also providing the police report, the next step is that Tony is still required to pay 1 month's rent, clean his apartment, and actually turn in his keys and leave. If he just waits for his landlord to get back to him, then he will be responsible for the rent during the time that he was living there. And this was a case that we, or it's based off of a case that we got at RMVLC, where the person just waited for several months for the landlord to get back to them. The landlord was being quite difficult and just did not respond at all. The landlord, unfortunately, is not required to respond within a 20-day period or any sort of time period. So sometimes it can be on the survivor themselves to, as well as providing all of the documentation to show up, turn in their keys, turn in the 1 month's rent, and leave at that point in time.
And that, I think, Sarah, correct me if I'm wrong, is a point of advocacy for anyone who is helping a survivor through this process, where we need to be really clear that, yes, this law allows for someone to relocate, to break their lease, but there are also these other steps that need to be taken, because I think, if I remember correctly, in this case, the survivor ended up having to pay for all of the months that they had not returned a key. Is that right?
Yes, because they had not properly gone through all of the, this end of lease procedure of turning in their keys and vacating the apartment. They were responsible for several months of rent. It's also important to note at this point that under the new law, a landlord cannot charge a survivor for damage that was created as a result of the victimization. For example, if during a domestic violence incident there was damage to a door or a wall, the survivor would not be responsible for that damage. However, if a survivor has damaged the unit in some way, just from regular wear and tear, knocked down blinds or something like that while hanging curtains, they are still responsible for any damage that was not a direct result of the assault or incident.
And so for policy wonks out there, what Sarah is referring to is this warranty of habitability, where it provides those protections for survivors. So as in the example just given, and even if a window is broken because a stalker entered the property and damaged a window to be able to enter the property, the survivor would not be responsible for the cost of repairing that window, because that was part of the crime committed against the survivor. So there are some protections in there. But if you are working with a survivor where the landlord is trying to charge them for damage done to property as a result of the crime, that's going to be another point of advocacy to connect with someone like Sarah, to connect with some sort of legal guide to be able to fully access these protections that are in House Bill 1035.
And it is also, we definitely understand that some survivors may say that they are interested in leaving as soon as possible, and do not want to stay to clean the apartment or to make any of those repairs that were kind of the regular wear and tear. And again, it's another point of advocacy and just providing the information that it is okay to leave immediately and to not go through all of those steps, but there could be some sort of financial backlash on that if it was not a direct result of the crime.
So we do have a question, but it's going back to case study number 1. And the question is,
okay,
is just having a SANE examination sufficient, or does there need to be specific finding of abuse?
That's a great question. Thank you for asking. So this is really interesting. With our licensed medical professionals, there is a process which they currently implement that is a type of victim verification. But as you know, if you are a licensed medical professional, or if you are someone who often encounters survivors who have done the SANE exam and maybe go forward with a court process, and that nurse practitioner comes to testify, is that licensed medical professional is not a law enforcement officer, right? It's not an investigator. It's not someone who can definitively say, yes, a crime occurred. But instead, what that licensed medical professional can do is create a statement that says that a survivor received I guess care is the right word, and correct me if I'm wrong, any of our licensed medical professionals out there listening, received care or patient services for a sexual assault forensic evidence collection. There is a similar process in place for survivors who are at risk of transmission for HIV infection. So currently, if a nurse practitioner or if a licensed medical professional, a SANE nurse, believes that a survivor has been exposed to HIV infection as a result of sexual assault, they can write a statement, write a letter to the drug company asking for free prophylaxis, and not verifying, right? Because they're not a law enforcement officer, they're not an investigator, they're not a judge. Not saying this person is a sexual assault survivor, therefore needs free medication, but instead that statement looks and sounds like, this person received patient care, sexual assault forensic evidence collection, and we believe that this person was exposed to HIV transmission, and we're requesting free prophylaxis. So the idea is that it will be a similar statement. It's not verifying that a sexual assault occurred, but it's saying that this person received services as a result of investigating sexual assault, and that therefore this person is eligible for this program. We believe that a statement from a licensed medical professional should be along the same lines, is that if a survivor receives the sexual assault forensic evidence collection, then a nurse is within their rights, their professional licensure, to create that statement that says that this person should be eligible for the protections under CRS. I can't remember the number off the top of my head. I can remember House Bill 1035 better. So hopefully that sheds a little bit of light and explanation for that process.
And in this case, the SANE nurse would need to provide that letter, similarly to the sample letters that we provided. The survivor would not be able to get, say, a copy of their medical records and bring that to the landlord. It does have to be a actual written notice, written and signed by the licensed medical professional themselves.
Thank you. Thank you for that question. Josh, do we have any more, or should we continue?
Nothing at this time.
Thank you.
Okay, so in case study number 3, Lena and John started dating in January 2016. They got married a year later and moved in together. John told Lena that she did not need to be on the lease, but she insisted. John resisted at first, but finally said it was fine as long as she didn't hold up the process by reading the entire 30-page lease because he needed to drop it off that very same day. Lena agreed. Several months later, John started physically abusing Lena. When she told him that she was going to call the police, John told her that the lease stated that she would be evicted if she called the police. Lena felt like she had no option but to stay with him since she would not be able to afford a deposit on a new apartment if evicted. Last month, Lena finally called the police because she was afraid for her life. The police came and arrested John. The next day, Lena got a notice on her door that she was being evicted because she had violated the lease by calling the police. Lena is afraid that she'll be evicted and has no place to go. What are the next steps for Lena? So this case study really speaks to what Rana was talking about earlier, in that landlords cannot actually put in their leases that someone can be evicted just for calling the police, and there are those protections in place. In this case, this would be a great place of advocacy for an advocate to be able to talk to be able to first educate the survivor that it's not legal, and at that point maybe provide a step to advocacy there for the to be able to talk to the landlord and just say that this is against the law and they're not able to be evicted for this reason. If the landlord is really not understanding and really insistent, which unfortunately can happen, then getting an attorney involved would be an option as well. And at Rocky Mountain Victim Law Center, we would be able to help with that also and be able to provide that additional advocacy and support there.
Sorry, this is Stevie. I just also wanted, and hopefully Sarah, maybe you can clarify this too. I think, as we know, every case can be so complex, and I think one of the complexities is we have these great protections, but a lot of times survivors don't know about them. And so in this case, Lena also could have followed that eviction, been evicted, and had that happen before she reached out to an advocate. And in that case, what are some of her options, Sarah?
So if she had actually been evicted at that point in time, there would unfortunately probably be an eviction on her record. And I don't know that there could necessarily be, I don't necessarily think that the bell could be unrung, so to say. Yeah. So in terms of educating survivors, that's one of the reasons that we are so excited to be doing this webinar today, and some future training opportunities, is that once there is an eviction on someone's record, there can be complications later on. And so really trying to make sure that we're involved before that happens.
Yeah. And I think too, this is Rana, I think that brings up a really great point of advocacy, Stevie, for our members, is that we should be conducting this education and outreach to landlords, whether that looks like the apartment association, a realtors association, private landlords who perhaps have worked with your program in the past to help housing survivors who are transitioning out of abusive situations. I think that this information is only going to be facilitated through our ability to connect with landlords to inform, because a lot of landlords don't know, survivors don't know, landlords don't know. This has only been in effect since June of this year, a few months now. And so really it's our job to continue to facilitate this information so that both landlords and survivors know what their rights are.
Mm-hmm. Yeah, no, I completely agree. Thank you, Rana. I just think we too often see, and as people mentioned at the beginning, that sometimes I don't want to say it's too late, but if you've already left and you've moved out, there's nothing really in this law that's going to be able to be retroactive. And so it's important as much as we can to get ahead of it. And we also know that many survivors have evictions already. And so just knowing that sometimes it's that advocacy and education that you can assist that survivor in those discussions with landlords and housing partners around why they may have evictions and other things on their record. So just keeping in mind that yes, these are great and we have to try to get ahead of it, and we also sometimes have to get creative, but we're all also here to support and provide resources. And as I said, I have some brochures written up specifically for landlords on these housing protections. So if you would like some of those as you're doing advocacy, my information's at the end. So feel free to let me know and I can mail you some.
Perfect. So kind of to wrap this up, we have a couple of definitions here for folks who may be concerned with the unauthorized practice of law. Again, please use Rocky Mountain Victim Law Center as a resource. If you feel that writing a victim verification statement may feel like unauthorized practice of law, please check with the folks at Rocky Mountain Victim Law Center first. Again, the 2 templates that we have in this webinar were created, one by Sarah, thank you Sarah, and one by the Address Confidentiality Program. So we're really hoping that folks will use those as templates. Sarah, do you want to jump in on any of?
Absolutely. And so as we have provided those templates, they are for information only. And just a reminder, in order to avoid unauthorized practice of law, providing legal information is acceptable and encouraged, but actually providing, applying that information to a person's circumstances would fall under legal advice, which is against the law unless you are a licensed attorney. So as you're going through, if someone does come to you and say, I've been a victim of sexual assault, I really want to get out of my lease, I don't know what to do, telling them you should break your lease and here's how to do it is not acceptable. Whereas if just providing the information that this law does exist and allowing them to make their own decision, or referring someone out to an attorney to provide that advice is the right way to go there.
Mm-hmm.
So a non-lawyer cannot provide legal advice, which I just described as applying a person's circumstances to legal information, cannot select legal documents on behalf of another person, draft legal documents, interpret the law as it may apply to another person's situation. And that's different also than just saying that a law does exist. Obviously, someone who's not an attorney cannot represent a person in a legal transaction or prepare another person's case for trial.
So I think that brings us to the end. If folks have any questions, we have a few minutes left and can field some of those. And otherwise, this is our individual contact information. As Stevie suggested, or as Stevie mentioned earlier, we have a couple of handouts of resources created. So connecting with Stevie at CCADV would be a good resource for folks. Sarah with Rocky Mountain Victim Law Center, especially if you're needing to dig into details of cases with someone who has the legal expertise to be able to apply the housing protections that are now in law. And essentially, if you have any specific questions about House Bill 1035, you can feel free to reach out to me. And other than that, I don't know, Sarah, Stevie, do we have any final closing comments?
No, I'd be happy to answer any questions that people have now, or if something comes up right after the webinar, where our emails are up here, and would be happy to field any questions offline as well.
Mm-hmm. Yeah, no, I would just concur with all of that and encourage you all to definitely reach out, because this stuff can be complex, but we also want as many survivors out there to know about their rights, and advocates to feel empowered to know that as well, and be able to better assist survivors in staying housed or getting rehoused, because we know that's just so crucial to safety. So we thank you so much for attending today. And yeah, I'm not sure if we have any questions, but.
So we don't have any questions that have come through just yet, and just giving everybody another couple of minutes potentially to chime in if they would like to. I also just wanted to follow up with the idea that, we discussed educating survivors and landlords, but also look inside of your communities to the other service providers. And we know survivors engage with so many various systems. So really expanding that education all the way out to all of the other service providers that survivors might find themselves working with, just so that there can be as many people as possible in every community who are aware of these protections.
Mm-hmm.
Is there anything else that anybody would like to say, presenters? We don't have any follow-up questions that have come through.
Okay. No, thank you all so much.
Wonderful.
Yeah, thank you, everyone. Thanks for taking time out of your day to stick with us. And if you have any questions, please use our groups as a resource.
And thank you to all of our presenters for providing all of this wonderful information. And then I just wanted to add before we leave, look out for the upcoming webinars from CICASA. We have a webinar on stalking on September 13th. And then we will also be looking at serving secondary survivors on September 27th. So look out for those announcements. And remember, there will be a survey that pops up at the close of this webinar. Thank you all again for attending, and we hope to see you again at our next webinars. Thank you all.